First of all, getting to a lawyer very promptly. The sooner the lawyer's involved, surprisingly, you would think, well, that means they're going to be involved longer. No, that can reduce the expense because the lawyer can find ways to try and resolve the dispute without litigation. But if you've delayed getting an attorney, tendency is that it involves lack of communication, and before you know it, you're on the doorsteps of a suit, and now you're turning it over to the lawyer after you've already been sued. If you see a potential problem, get the lawyer's advice early on, and you can usually head off a lot of expense that way. The other thing is that clients being very organized, making sure that you put things in writing. There's nothing worse to a lawyer is when he gets an issue, a case, and the client's explaining what happened, and it sounds great from that client's perspective, and then he said, okay, so where's the letter that proves you said that? Where's the email that documents that exchange occurred on that date? And they said, no, this wasn't any email. I just met him on the steps of the house. Or we had a telephone conversation, I think it was in September sometime. You don't have any phone records to document it. The lack of documentation then is just an invitation for fighting over whether or not something happened. But if you have it documented, that tends to make that issue a non-dispute and therefore closer, easier to resolve then at that point. So I think documentation, communication, and it's a fine line between over-communicating and under-communicating, but a client that is not calling the attorney every day, maybe saving some of the questions for, because they're going to, those point ones and point twos for those 2 and 5 minute and 6 minute calls end up adding up over time. And so making sure that you have your documents in a row, that you're organized with your questions, and communicating only to the extent necessary for your attorney to be effective for you.